I'd like to reserve 3 minutes if I may.
3 minutes. All right, sir.
Thank you, Your Honor. Your Honors, this case is an appeal of a summary judgment ruling concerning what is a nonsensical option notice provision in a commercial lease for a gas station and convenience store that's located at Poplar McLean in Memphis. My client, Nexus, has operated that gas station since it signed a lease drafted by the landlord in 2012. The lease has a 10-year initial term and 2 5-year option periods. The big problem with the lease, though, and why we're here, is that the lease has this nonsensical provision that says notice to exercise the option must be provided, quote, no less than 90 days prior to the initial term, end quote. Now, on its face, you take those words, notice was due 90 days before the initial term, prior to the initial term. Now, that means that before my client even signed the contract in June 2012, notice should have been given 90 days beforehand. It's clearly impossible. He couldn't have had, unless he had a time machine, he can't go back. At the trial court below, the parties filed cross motions for summary judgment. Summary judgment was entered in favor of the landlord, and my clients have appealed. But now, underlying this whole case is the fact that the landlord wanted to negotiate a new contract. My clients wanted to keep the original terms of the agreement. Now, this de novo appeal has 3 main issues that the appellants have raised. The first question is whether this nonsensical option notice provision is ambiguous, and by ambiguous, does it have more than one meaning? Or is this provision, does it only have one meaning that is impossible to perform and therefore void? The second issue is if the court believes that there is some notice that needs to be provided, even if they find that it's impossible to perform. The second question is, were the notices provided by my client sufficient to give the landlord notice of my client's intent to exercise the first 5-year option period? And those notices were the 2 letters of April 2022, as well as the 2019 fixture fee agreement. The third issue is that even if this court rewrites the contract as the landlord wants you to, and says, well, actually this meant notice was due 90 days before the end of the initial term, does the 2019 fixture fee agreement provide the landlord with sufficient notice of the tenant's intent to exercise the first option, where that 2019 fixture fee agreement had monthly payments that went to 2026, which was 4 years into the first 5-year option period.
Did that fixture fee agreement in 2019 not also have a specific provision that said nothing in that document would be construed to extend the term of the lease?
Yes, absolutely, Your Honor, and that's the key word, extend. And this was an argument we made below that the trial court didn't address, but there's nothing in the exercising the 5-year option period is not an extension of the lease. It doesn't change the term of the lease.
So what was the original term of the lease then?
The original term of the lease was 10 years and then 2 5-year option periods.
So how would a 5-year period not extend the 10-year period?
So it doesn't. So extend would be if you added to the 20 years. Extend means adding time to the term already provided. With the fixture fee agreement, it didn't extend. It just gave notice that the tenant is going to be using the first year option period. It doesn't add time at all. There's no time added. There's already a 10-year initial term and 2 5-year option periods. Now, the only issue is like whether notice had to be given. There's no extension of it. There's not like an additional, you get your 10-year initial term and 2 5-year options, plus because you're paying all this money, we're going to give you 4 more years on top of the 20. That would be an extension. There is no extension that occurred. All that was given was notice that my client clearly wanted to stay in the property through 2026 because he's making additional monthly payments for the gas equipment that's been installed. And that goes in well into the first 5-year option period. So it's not an extension, it's just a notice. And that was all that was, according to landlord, was all that was required.
Thank you.
Thank you, Your Honor. A few preliminary points that should be pointed out. One, the lease says that Georgia law applies. So we're going to be talking mainly about Georgia law, but we haven't seen any significant differences between Georgia and Tennessee law. Second, the standard of review is de novo. That applies for summary judgment orders, as well as any questions regarding contracts. The third issue is the burden. The party who alleges the breach has the burden of proof and persuasion. Here, the landlord has alleged in his complaint, particularly count 1, that my client is in breach, that we didn't provide notice, and that we're a holdover tenant. So the landlord has the burden. In the event of a tie, the win has to go to the tenant who has not asserted the breach. The first big issue we have is whether this contract is ambiguous or whether it is impossible and unenforceable. Now, under Georgia law and Tennessee law, the first step in determining whether a provision is ambiguous is whether, quote, the language may be fairly understood in more than one way. I'd also like to take the citation from the landlord and note that in the Bowers case, Bowers said, only if we find that there is more than one reasonable interpretation do we apply the rules of contract construction to resolve ambiguity. Okay, the very first step, square one, is that you have to take this provision and at least see two meanings. Two meanings have to be attributable to this text. In reading this quote, no less than 90 days prior to the initial term, there's only one meaning. It's nonsensical, it's absurd, it doesn't make any sense. It requires a time machine for it to be properly executed. But there is only one meaning. If you don't have two meanings, you don't have ambiguity. If there's no ambiguity, you don't go down to steps 2 and 3 and start applying the rules of construction. The trial court, in paragraph 6 of its order, said it's ambiguous. It gave no analysis for why. It didn't say that there are two meanings. The landlord, in the landlord's brief, doesn't explain how it's ambiguous. There is no second meaning. There's one impossible meaning that makes no sense.
What if you applied the impossibility rule?
Yes, Your Honor. So if there is no ambiguity, then under the impossibility provision, it's unenforceable and void. So that's under Georgia law. That's the Allen case cited in the brief. But also the lease itself says, well, if we have any portion that's declared illegal, void, or of no force or effect, you still have the balance of the lease. So if it's impossible, then you still have, then the notice requirement is void. Now, the court can take one or two options. One, if it's impossible, they can just throw out the notice requirement, there's no notice requirement. Or two, you can say, well, there has to be some notice. There's not a clear requirement for 90 days, but you have to give some notice. And that gets me to the second point. If the court gets to the position where some notice needs to be given, well, we told the landlord in 2019, we want to keep paying, we want the fixture fee agreement, we want the equipment, we're going to keep paying through 2026. We think the landlord got notice then. There were the two letters of April 19th and 20th of 2022. So, and that was 71 days. We think it's 71 days. They say it's 41 days. It's not really material for these motions. But we gave notice before the end of the term. And the other thing is that there's just no prejudice to the landlord. The landlord keeps his tenant, doesn't have to go find a new tenant, and all he has to do is comply with the terms that he agreed to in 2012. In contrast, you enforce this. It's not even enforced. The landlord has to rewrite the provision and then retroactively apply it negatively to my client, and my client's lost his business. It's not like, the business is at the location. You take him out, his business is gone. So the drastic consequence that the landlord is seeking is unreasonable and unfair also.
So in other words, if the issue is impossible, or if the requirement contained in the contract is impossible, then it basically puts the court in a position of rewriting the contract. Would that be accurate?
If it's impossible, no, Your Honor, I think, well, there are two options. One, I think the proper step, and I think the first step I would suggest, is you just strike through that sentence, at least retroactively. Now, the second count.
Doesn't the contract contemplate notice? Isn't that, I mean, there's no way you can read the contract other than to say that if you're going to renew these options or take these options, then some notice must be given.
Yes, Your Honor. So that's the second option. And so if you say there has to be some notice, but there is no exact time limit, I think we have substantial compliance with no specific.
What does Georgia law say about if there is no requirement, or if there is a requirement for notice in a contract? How do you ascertain what that time period would be?
With the timing requirement? I didn't find any case on point. I don't think anyone's raised that, but I would think substantial, well, there is case law that says substantial compliance allows for compliance, or substantial compliance allows for.
Different than notice, though, isn't it?
Sir?
That's different than notice, isn't it?
Yeah, I guess, so we did provide notice, so I think we're good on that. We provided notice in April of 2022.
It depends on what Georgia law says, how you determine what notice is required. Isn't that right? Assuming that we follow option 2, or that option 2 is viable here.
Yes, Your Honor. I didn't find any case law. That's really not an issue that's been raised, Your Honor. But if that is an issue, that's not something raised in the summary judgment brief. So that'd be something else to remand for the court to consider. But I think.
Yeah. Let me ask you.
Yes, Your Honor.
You say you gave notice earlier.
Yes, Your Honor.
Does that notice that was given, does it say this is a notice that we're exercising the first option of 5 years?
It doesn't say explicitly that we're exercising the option for 5 years, but it does say we're making payments through 2026 for new equipment that's being installed a little over 2 years before the end of the initial term. So just the context of itself and the understanding of the parties, I don't think a reasonable party entering into that fixed fee agreement would ever think, all right, in a couple years he's going to be out of here, even though he's agreeing to pay monthly payments through 2026, 4 years after the initial term ends. I don't think that's just a reasonable interpretation, Your Honor. I see I'm out of time. Thank you.
Got your rebuttal time.
Thank you.
Good morning.
Good morning.
May it please the court, I'm John Heflin of the Memphis Bar, and I represent the landlord, Poplar Avenue 1856, in this matter, in this lease dispute in which you've heard just now that you are invited to adopt an interpretation of contract language that the appellant says is nonsensical. And that's his position, and I want to point out to the court that that's very much contrary to Georgia law, which controls. But before I say that, I want to reemphasize that this is a case in which both sides filed for summary judgment. So there's no dispute about what the facts are. And the facts are, as the tenant, and I'm going to refer to tenant singular, although it is a man who owns a corporation and both are listed as tenants. So excuse the singular also includes the plural, but the tenant individual admitted he did not read the lease in its entirety. He admitted that he did not give notice of exercise of the option per the language of the lease, although he contests the language of the lease. And he admits that the first time he read that renewal option provision was after he had received a letter saying the lease would terminate because no exercise of the option to extend had occurred. Now, what's important, what's critical that I want to convey to the court is that Georgia cases do not permit a construction of contract language that is unreasonable or nonsensical, as the appellant would say, when there's a reasonable interpretation. And I've cited 3 very interesting cases which demonstrate that the appellant's argument is incorrect. In the and first of all, the Georgia contract law is a little bit different than Tennessee, because in my years of practice, which I sometimes like to think I'm still a young lawyer, but unfortunately that's not true. But in the many years I've dealt with contract language, when we talk about contract language, we talk about the rules of contract construction. But Georgia says something different. Georgia says, first of all, determine if the language is ambiguous. And the Georgia cases say at that step, a construction that is unreasonable, it should not be adopted if a reasonable construction can be adopted. Then it says, step two, if looking at it and determining with the idea that the language needs to be construed in a reasonable manner, if that doesn't cure it, then you apply the rules of construction. And there's a statute in Georgia that sets out the rules of construction of contracts. Only if both of those steps fail does it become an issue of fact for the trier of fact. Now, I've cited 3 cases that are really important because they demonstrate that the appellant's argument fails. And the first one is that Caswell case. And it's interesting because that case involved the sale by a partner of his partnership interest. And he got cash, partly in cash, for that partnership interest. And the agreement said, if we sell partnership property within a period of time, you'll get a portion of that, quote, subject in each case to a credit for what we've paid you. Listen to that language, subject in each case to the credit, to what we've paid you. So the partnership sold some property. They gave him his percentage, less taking the credit for what they paid him. Then they sold some more property. And the partnership said, well, we're going to take that credit again, the same credit. Then they sold some more property. And they said, well, we're going to take the credit again. The language said, quote, subject in each case to a credit. It went to the Georgia court, which said, absolutely wrong. That language can't be construed reasonably in that manner because you don't get the credit 2 or 3 times. You get the credit once because you only paid him once. And so the court looked and said, we're looking at that language, and you can argue that that language says exactly what it said, subject in each case to a credit. But that language can't reasonably be construed to mean that. The Bowers case is another case where if you look at the language and you apply a nonsensical interpretation to it, then it means something different than what the court ultimately held. The Bowers case is a case where a gentleman took out a non-recourse loan. But the non-recourse loan said this becomes recourse if this property that you're borrowing the money for goes into a voluntary receivership. Well, the property was not successful. The loan, the business was not successful, and the borrower turned the property back over to the lender. And the lender came to the borrower and said, it would help us to put this into a receivership. And so the borrower said, well, I'll accommodate you. Whatever you want to do is just fine. After the lender put it into a receivership, the lender then said, well, this has become a recourse loan. Because if you look at the language, it says if it goes into a voluntary receivership, then it becomes a recourse loan. And the court said, that's not a reasonable interpretation of that language. You have to say, the intent of that language was always that if the borrower put it into a receivership, then it's going to become recourse. Not for him to accommodate when he turned it over back to the lender. The third case, which is the 2880 Chambly case that is in my brief, is a case in which the language of the agreement, it was a lease of property in a shopping center. the language said that there was an agreement that the tenant would not compete with other tenants in the retail center. And the court looked at that and determined that that didn't mean, even though there's no territorial restriction, it didn't mean you can't compete with, if you have a McDonald's in there, you can never compete with the McDonald's anywhere. The court said, even though it's not in in there, the only reasonable construction is it pertains to at that center, even though that language is not there. This case, if Your Honor wanted, if the court wanted to put this language absolutely under a microscope, in section 33, which is the option to renew the lease for 2 additional 5-year terms, the word term, where it says the option shall be exercised by written notice given to the landlord no less than 90 days prior to the initial term, term is capitalized. When you capitalize something, it means that there's a definition. If you go back to paragraph 2 of the lease, that says, quote, the term of this lease shall be for 10 years commencing on the date that the landlord turns over the premises to the tenant, but not later than May 31, 2012, which is then defined as, quote, the commencement date. That's not, so there's a definition for commencement date. He's saying the term means commencement date, but there's a defined, commencement date is a defined term. Then it goes on and says, and expiring on the date, which is 10 years from the commencement date, parentheses, quote, the term. So the word the term in paragraph 2 is defined as the date which is 10 years from the commencement date, which is the end of the period. Now, I think of term as extending to the entire 10 years. But if you want to be literal and look at and say, okay, what does in paragraph 2 the word term refer to? The words before that, quote, the term, say the date which is 10 years from that. I want to quote it correctly. The date which is 10 years from the commencement date, parentheses, quote, the term. Georgia case law absolutely requires that the court look at the language of the lease and adopt a construction that is reasonable, just as the trial court did. It also, if the court, and that's step number 1. If you went to step number 2, the same rule of construction applies at step number 2. If you say, okay, we didn't resolve it in step 1, but what are the rules of construction? Well, the rules of construction require not only that you apply a meaning that is reasonable, but also that you apply a meaning that is consistent and in harmony with all of the other contract provisions. Your Honor asked about, well, if there's notice, how much notice should there be? Recognize it provides for 90 days. There's also a provision that says the landlord is entitled, if the lease is going to end, 60 days before the lease is going to end, to be able to come onto the property and card it and show it to prospective new replacement tenants, drying out potential purchasers. And so to harmonize those provisions, the 90 days is necessary so the landlord knows, okay, I need to put this property up, I need to locate somebody, advertise, say I'm either going to sell it or I'm going to find a new tenant, and then start showing the property 60 days in advance. So the requirement of harmonizing the language is of course, as well as in Tennessee law, it's in the statute that we've cited, the Georgia statute. I do want to mention, because I consider it very important, the language of the fixture fee agreement, which very creatively has been argued not to apply to the words extend. We disagree with that, but I want to point out that in addition to paragraph 3 of the fixture fee agreement, which says nothing herein shall be construed by either party to extend the term of the lease, which we could submit means exactly what it says. What does paragraph 4 immediately following it say? It says, except as expressly set forth in this agreement, The lease and any other documents related to the premises are hereby ratified and remain in full force and effect. Each party acknowledges and agrees that no representations, inducements, promises, or statements, written or implied, have been made by any party or anyone acting on behalf of any party which are not embodied in the lease or this agreement. So it says nothing even by implication is changed. And that is an agreement that the appellant signed but wants to ignore. I also want to point out and refer the court, in my brief I cited many cases that are many Georgia cases that talk about the argument about substantial compliance with the notice provision. And Georgia courts are very uniform in saying two things. One, they say that we will honor a recitation in a contract that time is of the essence. And they say, even though we may not think that this would be a contract where time would be of the essence, if the parties say in their contract that time is of the essence, then the Georgia courts will honor that provision. Then there's a separate related line of cases that talk about option contracts, whether there are options to purchase, options to extend, and they say, those Georgia cases, which are cited in my brief, say that whether or not in those option contracts there is a recital that time is of the essence. Time is always of the essence in those contracts. And whether it's recited or not, time is of the essence, and failure to strictly comply with the requirements of the contract are fatal. The last point that I would want to make is that the court below did award us fees pursuant to the contract. The lease provides that in this unfortunate kind of situation, the prevailing party is entitled to fees. That would include fees on appeal. And I'm going to give up my last 40 seconds unless the court has a question.
I see none. Thank you.
Your Honors, if I could just hit a few points that Mr. Heflin raised. First, he points out that the tenant didn't read the provision of the lease regarding the option to renew until the 10th year. Now, that actually cuts in favor of my client. The case law says that if one of the parties is aware of an impossible provision, then they can't then rely on that later on. My client wasn't a snake lying in the weeds waiting to attack on this notice provision. He didn't know about the notice provision. The second point is that regardless of whether a party knows or has read a provision, the provision still applies as written. So if you're going to limit provisions enforceability to whether the parties read it, well, that's going to be a complicated situation going forward for all contracts. The construction argument. Landlord makes a lot of arguments about construction. He starts at step 2. You only get to the construction arguments if at step 1 you have an ambiguity with 2 meanings. Every case, and I really could have used every case cited by the landlord in my favor. One example is the Simons case. In the Simons case, there were 2 meanings for the phrase that notice is due not later than 3 months from the termination of said lease. From the termination of said lease has 2 meanings. It could be before or it could be after. Every single case cited by the landlord with an ambiguity had 2 potential meanings. Now maybe one was reasonable and one was a little crazy, but there were 2 meanings before they got to the construction issues.
And what did the court say about that? Ultimately, the 3 months from.
So in the 3 months from, there was an ambiguity because you had 2 meanings, and then they said, well, the only reasonable interpretation is that it has to be 3 months before, not 3 months after. But before the court, the important point is, before the court could get to that construction, the court had to find an ambiguity. Here, there is no ambiguity. It's just a nonsensical phrase that the landlord drafted. It says notice is due 90 days prior to the initial term. Now, whether you use the transitive property like he's suggesting I've argued, which I haven't, or you just look at the phrase itself, 90 days prior to the initial term is 90 days before the term. 90 days before. That means 90 days before my client even signed the contract, that's when notice was due. Going back to your point, Mr. Judge Stafford, what Georgia law would require is that you strike from the lease that notices the timing of it. The notice is due 90 days prior to. So written notice is still due, but we did give written notice. We gave it through the fixture fee agreement and then the letters of April 19 and 20, 2022. We'd respectfully request that the court reverse the trial court's grant of temporary injunction in favor of the landlord and then enter summary judgment in favor of the tenant.
Let me ask you, why shouldn't that just be prior to the initial term of the option?
So you would have to add language. You have to insert prior to the end of the initial term. All right, two main reasons.
Prior to the initial term of the 5-year option. Isn't it clear that that's what it meant?
It's not, Your Honor. I know, so initial term of the 5-year option?
Yes.
I don't understand.
It's under the option provision.
Mm-hmm.
And it's saying you have to give notice 90 days prior to the initial term. Not of the original lease, but of the new option period.
Well, the initial term, though, is defined in paragraph 2. The initial term is the 10-year, the commencement date, the term is the 10 years. I don't think the initial term, the term initial could be referencing the first option period. I mean, initial means the beginning, the first. I don't think there's a way that you can steer it, but I think secondly, you have to add language to get to that potential meeting. And third, even if you start inserting language, it makes it unclear, well, how do you exercise notice for the third option or for the second option? I think the landlord wants to add no less than 90 days prior to the end of the initial term is really what he wants it to read. But then that makes no sense for the second option. The thing is, it was badly written and just needs to be rewritten. I think there needs to be a reformation of the contract, which is the second count of his complaint, and that should go forward.
Okay.
Thank you, Your Honor.
Thank you. Thank you, counsel. We will take this matter under advisement, review the record, and endeavor to provide you with an opinion at the earliest possible date. Thank you. Thank you. We're very pleased to have the University of Memphis represented here today from law school, and hope you've enjoyed it, Ms. Haley. I did. Good, good. Always good to see you. Always good to see you too. All right, we'll stand in recess to the call. Oh, I'm sorry.
If I may, I'd like to introduce my associate, Harley Chapman.
Yes.
Second year, recent graduate from the University of Memphis. And she did moot court in law school. She loves appellate arguments and briefing and argument. So she came with me today, and we're excited to have her in the firm, and thank you for